by way of introduction, my name is Mike Miller. I'm the Chief Marketing Officer at Pryor Cashman. We're a 180 attorney law firm in New York. We have offices in LA and Miami. And I've been working with small businesses really throughout the life cycle in an array of needs. It's a really difficult time for you folks, and want to be here, want to provide a lifeline for you, and really help in any way we can. So to that end, I have a couple of brilliant people who are going to really take away all the talking and insights. First of all, I'd like to introduce Chris Loeber. He heads our insurance recovery practice and has really been working around the clock with small businesses really around the country to help them to navigate the new normal. And so with that, I'll kick it over to Chris. But just for those of you who are new to Zoom, I want to just give you a few sort of quick highlights. If you look to your top right, you'll see a speaker view. You can change that. You may have a speaker view or a gallery view. Gallery view looks kind of like the Brady Bunch there. Speaker view is the person who is directly talking. That is entirely your call how you want to do that. Your bottom left, you'll see a mute button. Keep it on mute. Obviously, we all have a lot of distractions, whether it's kids or puppies or sirens or whatever it is. So feel free to do that. Start video, stop videos would show your gorgeous faces out there. And we also have a chat function, which you can feel free to ask us questions throughout. You can send them directly to me, Mike Miller, or to the marketing department, and I'm happy to sort of aggregate those. But without further ado, kick it over to Chris. Thanks.
All right, great. Thanks, Mike. So what we thought we would do is do this in kind of a structured way. We want to give a brief overview of the insurance industry and who the different players are. Then we want to talk a little bit about the types of policies that could respond to COVID claims. After that, we'll talk about some of we'll get into the weeds a little bit on, positions that we're seeing the insurance industry take, that we're hearing from brokers. And then my colleague Mallory Chandler's on the phone now. She's on our COVID response team for insurance. And so she's going to talk a little bit about some of the legislative developments that we're seeing. So different states are trying to get into the act here of attempting to force the insurance industry to provide coverage, particularly for small businesses. And Mallory will talk a little bit about that and where we think that might go. And then at the end, we'll wrap it up. And as Mike indicated, you all can shoot questions into Mike on the chat function, and we're happy to answer as many questions as we can. I think the thing that we need to start with, though, is this presentation is not designed to provide any specific legal advice. Your insurance policies are a very specific contract, and so in order to give any advice that's directed to your business or to your specific situation, we would need to look at that policy. This is instead designed to give folks an overview. We're finding, particularly among our small business clients, that there are a lot of questions out there that are unanswered, and we're offering these presentations just to give people kind of a sense of what's going on, hopefully provide a little bit of comfort, and at least give some high level guidance as to what you should be doing at this time in order to protect yourself. Okay, so in terms of just a general overview, as Mike indicated, I head up the insurance coverage practice at Pryor Cashman, and we represent policyholders only. We largely, our job consists of working with clients of all shapes and sizes when they have disputes with their insurance carriers, and we get those disputes resolved. As often as we can, we try to do that through negotiation, but sometimes it requires litigation, and so we'll go and we'll go into court and we'll fight for the policyholders' rights under the insurance contract that you have. Because of our view on this, I tend to be somewhat biased as how I look at things. Early in my career, I represented insurance companies, and now I've switched to the side of policyholders. So I have a good sense of how insurance companies approach things, and all that you're going to hear today comes from that perspective, trying to give policyholders the tools they need to go to get out there and try to get their rights protected under the policy. So um, there are two types of policies that could respond to COVID-19 related losses. The first type are called first party policies, and those are your property policies. You take a first party policy out to protect your business, your physical equipment. And that first party property has a second component to it, which is the business interruption. And so you all may be familiar with that. There's a lot of talk going on now about business interruption. That's really where we're going to focus today. But I wanted to, at the top, just talk about another type of coverage, and that's third-party coverage. So whereas your first-party coverage, your property policy, will respond to losses that you sustain at your business and the loss of income that you sustain, third-party policies are those that respond to damage that you might cause to someone else. So the most common type of third-party policy is a general liability policy. Most folks are familiar with those. That protects you if you should, obviously not intentionally, but you inadvertently cause damage to someone, damage someone's property, or cause some type of bodily injury to them. Down the road, it may develop as the dust settles on this quarantining, when life gets back to normal. There may be claims made against small businesses that would trigger the general liability policy. Someone might say, I came into your place of business, I didn't have COVID, I wasn't infected, and when I left, I was, and therefore you did this to me, and I'm going to sue you. That would be the type of policy, or the type of claim rather, that would be covered by your general liability policy. Potentially, maybe it's covered, maybe it's not, but that's something for a later time. What we're going to be focusing on now is the immediate damage that's been caused, and that is along the lines of your property damage and your business interruption. So let me talk about the property policies. One of the issues that we're seeing, and one of the things that becomes difficult here, is this initial question of whether there has been direct physical loss or damage to your business. Many of you may have seen over the weekend, there were tornadoes that ripped through the South and really took devastating effect. That type of property damage is very easy for the insurance industry to get its hands around, because they can say, all right, look, it's clear, tornado came through your area, your home or business has been destroyed, we can see it, we can touch it, we know that that's physical damage. And therefore that would be a trigger under pretty much any property policy. It becomes trickier when you're dealing with a microorganism like a virus, because it's very possible that you could have had contamination in your business and you wouldn't know it, because it's not visible. The insurance company can't come in and say, oh yes, now I see that this property was specifically damaged by this virus. Now, does that mean that there's no coverage? Well, the insurance industry would like everyone to believe that there is no coverage for loss that you can't see. But the reality is that that's not the case. There have been lawsuits long before COVID was even on anybody's radar. There have been lawsuits that deal with this question as to whether microscopic or whether invisible contaminants could cause damage that would trigger a property policy. And the answer is yes, they can. So that's one question. Did you sustain physical loss or damage at your property? If you have sustained that type of loss, in other words, if you know that either yourself or an employee or a customer has been infected and was in your place of business, then that would allow the argument that you did sustain direct physical loss or damage as a result of COVID-19. We have to be very careful, and I need to caution here that there are a lot of different issues at play. I'm talking today, and Mallory's going to be talking only about the insurance piece of this. You need to keep in mind that there are other issues. You have potential privacy issues. You certainly don't want to be broadcasting the fact that you had an employee or you had a customer who had tested positive for COVID, because then you're running a risk of potentially violating someone else's privacy rights. There are employment issues that come up. small businesses, just like anyone else, if you have employees that you have to furlough, if you have benefit questions that come up, what do you do? How do you handle the continued payroll issues that you have, or payment of benefits? All of those are other issues we are working with many of our other partners in trying to answer those questions for folks. So please just keep in mind, today we're talking only about insurance. So we talked about a situation, if you have a known contamination at your place of business, that could create one pathway to coverage. Another pathway to coverage could be created if you did not have any damage at your facility, but you were impacted by a governmental shutdown. And we talked to people all over the country, and different cities and different states are taking different measures to combat this. Many have put restrictions in place as to what type of business can remain open, how many hours a day that business can remain open. Even in some cases, we're seeing in some states, you're allowed to go into certain businesses, but they're walling off certain areas. So there are only certain things you can buy and within those businesses. So this is important because when we're talking about your property policy, after we look at the first section of that coverage, which is the physical damage that's occurred, you look at the second part of that coverage, which deals with business interruption losses. Here's the theory. If the insurance industry recognizes that you have sustained a loss at your business, then they also will accept that once your physical damage is repaired, your property is repaired or replaced, there's going to be a second hit you take, and that's going to be in business income. Sometimes it's called time element coverage. Sometimes it's referred to as business interruption coverage. Sometimes it's referred to as business income or business loss. That's really where the focus is going to be. And for the balance of this presentation, we're going to really be talking about that business income loss, because that's where your business has a direct and sometimes extended, it takes an extended hit because of the damage that caused. When you look at the business interruption section of your policy, you will find that it has many different buckets of coverage. The most common is a loss profits analysis. So the insurance company would say, okay, if we accept that you've had some loss, we will then look at what your policy provides. And each policy is different, but most policies will provide up to 12 months, sometimes it's longer than that, of a period of restoration. That means the time that it should take you to get back up to where you were before the event occurred. And what the insurance company will do is say, we will pay you the lost profits during that period of restoration. And this is an oversimplification, but what it requires is you need to demonstrate as the policyholder that, in this case, COVID-19 was the reason why you sustained a loss of profits. The insurance industry is going to come back, and they're going to push very hard here, and they're going to come up with every reason under the sun except COVID to say that you're to blame for the loss in profits. Okay, and again, it's not revenues, it's profits. In addition to the business income coverage, there are a number of different subcategories of coverage that are included in your business income contract. I'm just going to talk about a few of them. There are many, and we could go on. This thing could last all day talking about all the intricacies, but there are two in particular that I want to talk about. The one is called civil authority. That's one that a lot of people have focused on, and I mentioned that earlier. That's where a government comes in and prevents access to your business. That is obviously a type of business interruption, and many policies do cover your civil authority. Sometimes it's military authority. New York area, we saw the National Guard coming into New Rochelle, for example, when New Rochelle was the epicenter of the outbreak. So any military authority, any civil authority that comes in and determines that it's not safe to operate your business, you may have coverage for that. The second type of coverage that's found in the business interruption policy, in the business interruption section of your property policy. It's called extra expense coverage. This is a very broad category that basically is designed to reimburse any costs that you had to lay out in order to get your business back up and running to what you would call normal. So you would want to get to through all of this mess that we're in right now. You want to get back up to where you were before anything started. And the extra expenses, I said, broadly worded. There's any number of costs that could fall into that bucket. Okay. So let's talk now a little bit more about where the coverage claim goes here. A typical insurance policy has lists of events that are covered, and it has then the conditions for coverage, and it also has exclusions to coverage. And one of the things that you all may be hearing about is the talk that's centering on the exclusions to many of these policies. And the most common exclusion, and many of you may have them in your policies, is a bacteria and virus exclusion. And the history of this is that if you go back to the 2005, 2006 timeframe, in some cases even earlier, some epidemics that broke out led the insurance industry to start studying whether they wanted to provide coverage for these large-scale virus outbreaks, bacterial outbreaks. Think about SARS and MERS and Ebola and situations like that obviously didn't reach the scale, but it did lead the insurance industry to put an exclusion, a blanket exclusion in many policies that says there is no way that we are ever going to provide any coverage for any losses that arise out of a virus. That's one way that you can they attempt to exclude coverage for what we're dealing with right now. And there's a second way, and the second way is a little more subtle, and that's where the insurance industry puts a broad exclusion in their policies called a pollution exclusion. And so what they say is, we're not going to, in this property policy, we're not going to pay for any losses that are the result of a pollution event. And then what they do is they define the term pollutant very, very broadly. And they include in the definition of pollutant a virus. So basically what they would do in a bit of a roundabout way, they would say, oh, well, you're coming to us because of losses that you sustained as a result of the virus. And that is a pollutant as defined in our policy. And our policy does not provide any coverage for pollution-related events. So it's a little more subtle than the blanket virus exclusion, but it's also very common. Just as a quick aside, one of the reasons that the insurance company puts exclusion in policies is because they want you to buy another policy. So widely available on the market is what's called a pollution legal liability policy. Some of you may have that, but you may not. Wherever the insurance company can sell you a different policy, they will exclude what's in that different policy from your existing policy. It just makes business sense. So the question becomes, what do we do with these exclusions? If you have an exclusion in your policy, do you simply throw up your hands and say, well, I'm not going to get coverage, so I might as well not even make a claim? The insurance company would love you to do that. And many insurance brokers are also advising their clients not to make claims. Our position on this is the exact opposite. Mallory's going to talk in a little bit about the legislative changes that are going on right now. But there are two general reasons why we're encouraging people to make claims, even if you have these exclusions in your policy. Then the one reason is because under your policy, and this is something that's through every policy, I don't have to look at the individual policies to know this, there are certain obligations you have as the policyholder. And those obligations require that you notify the insurance carrier as soon as you become aware of an event that could give rise to a claim. If you don't give timely notice of a claim and you wait, and you go back at a later date and try to make a claim, the insurance company is going to say, no, you're barred from making that claim because it's now too late. So what we're looking at is we're looking at a situation where everybody knows that they're being impacted by COVID. Everybody knows that their losses are going to continue as a result of COVID. So what we're doing is we're advising our clients to look into those policies, to tender a claim, and it may have to be a broad claim saying we were impacted by COVID, and it clearly triggers coverage under the policy, and we now are making a claim. That will lead the insurance company to assign an adjuster. They come back and they may do one of two things. They may come back and say, well, you know, we'll get back to you. We acknowledge your claim. We'll give you more information, or we'll come back to you for more information, and then we'll make a coverage determination down the road. Or one of the other things that we're finding is, in many cases, the insurance carriers are just, they just have a blanket denial letter that they're sending out. Now, interestingly, what we're seeing for many of our clients is they're making a claim and they're getting an immediate denial from their insurance carrier. But that denial is based upon provisions that aren't even in our clients' policies. And that's because they're trying to get out ahead of this, and they're trying to discourage claims. So what we need to do is we need everybody to get into the claim process. Even if it results in a denial, you get your claim out there and you've driven a stake into the ground of the current policy, and you've basically cut off any argument the insurance carriers could make at a later date that you didn't timely notify of the claim.
Hey,
Because
Chris,
what's going to happen? Yeah.
just quick question there for clarification. What is a timely claim per se? Is it people need to be doing this in the next month, or what's?
Yeah, no, that's it. No, that's a good point. What we're looking at is language that generally says, as soon as practicable, sort of the weird word that they use, right? Which is a loose term. It's ambiguous. It's not a set period of time. You don't have there's no specific number of days. But the idea is that if you are aware of it now, you are aware of this event now and the impact that it's having, then it should be a matter of weeks and not months that you make that tender. So weeks, days. I mean, I'm not trying to scare everybody that, oh my God, if I haven't done it so far, I'm too late. But we are now in a position where everyone knows what the impact is. And so, over the next week or 10 days, people really should be putting their claims, and certainly as soon as they are aware and as soon as they're able to do. So just moving on, what we're talking about here is putting those claims in. What's going to happen over the next weeks and months is that there's going to be a lot of litigation over this. And I'm going to come back and talk about that a little bit. And in just a moment, I'm going to toss it over to Mallory to talk about some of the state and federal moves that are happening here that you should be aware of. Before I do that, I want to just give another kind of general or make a general comment about the way insurance law works in the United States. There is no federal body of insurance law. Insurance case law, insurance regulation occurs on a state-to-state basis. And so Mallory will talk a little bit about the different states that are starting to become active here. And but keep in mind, and she's going to talk about the federal government too. And while the federal government can take some action that we'll talk about, it's important to realize that the state where you operate your business is the state that's going to have the largest determining factor on whether or not you may get coverage, even in the event of or even in cases where you have these blanket virus exclusions in your policy. So with that, let me hand it off to Mallory. She can talk a little bit about these changes that we're seeing, and then we'll come back and we'll talk about a couple of more things, and then we'll take some questions. So Mallory, take it away.
All right. Hi, everyone. So I'm going to talk about the different state and federal legislation that's being proposed to mitigate these business losses, business interruption losses, it's being called. So I'll start with the states. 5 states right now have proposed some legislation that will, mitigate these business interruption losses. And of course, they're getting a lot of pushback from the insurance companies, the insurance industry as a whole, and they're saying, well, how can you force us to cover for something that we didn't contract for? And this goes back to what Chris was saying about pollution coverage, in that the states are saying, well, it's about fairness, right? You provide these blanket exclusions for viruses and bacteria, and you may even put it in your pollution policy, but you don't have another policy to sell us for virus and bacteria, which is, generally some do, but in the most part. So they're saying, so you can't exclude something that isn't, you can't cover for us in another policy. So that's what the states are saying. It's been 5 states so far: New York, New Jersey was the first one actually, Ohio, Massachusetts, most recently Louisiana. They all basically say the same thing, which is, hi, insurance companies, if you issued a policy that excluded coverage for virus or bacteria or something that COVID-19 would be encompassed under, well, now you cover it. They all kind of have a retroactive date to the state of emergency date that the states issued. So, that varies March 7th to 11th. And it's aimed at small businesses. So they've been defining small businesses at 100 or fewer employees. I think Massachusetts has defined it as 150 or fewer. Louisiana has 2 bills out right now. One defines it, the House bill defines it as 100 or fewer. The Senate bill doesn't have a size limit. So, they vary, but they all, get to the same point, which is we want these small businesses to have coverage for these business interruption losses. So that's the states. Federal, like Chris said, insurance is a state-by-state business, but the federal government has proposed, it's very early proposal, like in the last couple of days, something called the Pandemic Risk Insurance Act. Tria is the cute little name they gave it. And basically it would set up a compensation fund for insurance companies. They would, contribute a certain amount, probably based on the amount of money they sold in policies for a certain year. And the claimants would have the choice. The fund would cover you for business interruption losses if you didn't have that coverage for COVID-19, and it would offer a way to expedite the claims process. The insurance companies would have to say, okay, we're liable, and probably the claimants would have to accept, up to 80–90% of their losses, whatever it is. So they're looking into something like that to maybe just spread the wealth of loss across the insurance industry, and also to get money into small businesses' pockets more quickly, so that you can get back to work and get back to having a better economy. So that's going on the federal front. And the reason this is important is because a lot of your policies, if not all, have what's called a liberalization clause. So a liberalization clause more or less says, if something happens during the policy period, your policy term, that expands coverage, you have now that expanded coverage. So for something like this, legislative policy or bill that's introduced and that broadens coverage, well, because of that liberalization clause, you would now have that broadened coverage. So the reason it's important, like Chris was saying, is you want to tender claims early, because you could, obviously these are just proposed bills, nothing has happened yet, but because of those notice provisions in your policies that say, as soon as you know the loss, you have to let us know. If you wait, and you say, well, I'm going to see how this legislation goes. If it doesn't apply to me, why am I going to waste my time tendering a claim? And you wait, and 6, 7, 8 months from now, it's enacted, and you're like, nice, this does apply to me. I'm going to tender a claim now. The insurance companies are going to push back, and they're going to say, well, hold on, like, you've had business losses from March, and you're telling us now in November, you know, and they're going to give you a hard time. So one of the main reasons of, if not one of the many reasons to tender now, is to, you know, fight that argument, to just give the insurance companies less ammunition to deny your claim. So that's what's going on the legislative front. It's interesting. It's interesting to me. And we'll be keeping track of it. And yeah, that's it. Chris, do you have anything to add?
Great.
To that?
Yeah, just no, that was great. The a little different perspective on this too, and just so people understand what we're dealing with. The insurance industry as a whole reserves a certain amount of money each year based on what they believe their liability and their potential payouts, you know, the levels they might hit. The insurance industry for this year in the US has put together, I guess their figures say that they're going to face potentially about 800 billion in losses. That's everything. We're coming into hurricane season now. Obviously, you know, Tornado Alley is very active, as shown over the weekend. Wildfires happen all the time. There are all types of catastrophic losses that happen. And the insurance industry has estimated before COVID came about that it would be safe to reserve about $800 billion to cover all those losses. The losses that are estimated to flow from COVID are running at 200 billion to 300 billion, that's with a B, per month. So that will give you a sense of where this thing really is headed from an economic standpoint. And it also gives you a sense of why the insurance industry is going to push very, very hard against these losses. As Mallory indicated, their argument is going to be, we did not intend to cover these losses, and therefore we're not going to. And if you, in some cases, if you believe you have this coverage, then you're going to have to sue us for it. Now, there are other avenues, and what we look at when we're studying policies and we're studying case law is the actual wording of a given policy. Because you can have a policy that does create a pathway to coverage. You may have a policy that says that requires, in order to be triggered, direct physical loss or damage at your property. And that would go to what I said at the top, which is that you would need to show that you had a direct physical impact, meaning someone was there in your place of business that was infected, and that person then spread, and because we know it's incredibly contagious, if someone was in your facility, your place of business, and they were infected, then there is a very, very good chance that the virus was spread around your facility, opening the argument that there was damage caused by the virus. But your policy might be worded slightly differently. Instead of saying direct physical loss or damage, your policy might say direct physical loss of or damage to your property. And if you're talking about the loss of your property, that may open a pathway to coverage that doesn't require any viral contamination. What you might say in that situation is, well, the government shut down, you know, the city of New York effectively, and my business was in the city of New York, and there's no proof that there was COVID anywhere near my business, but I lost the use of that property. And so I can claim under the civil authority coverage, for example. So it all comes down to the specific wording, and it may sound a bit like semantics, but well, and maybe it is, but that's the world in which we live. So the key from an insurance perspective, when you're talking about you know, policy interpretation, this is very important. Even though the law has developed on a state-by-state basis, there are certain principles that every state follows. And one of the principles it comes down to the reasonable expectations of coverage and the reasonable interpretations of your policy. And so if the insurance company comes up with an explanation of your policy wording that cuts against coverage, and you as the policyholder come up with a reasonable expectation or reasonable explanation of your policy that supports coverage, then in every state in the country, the policyholder is going to win that tie. And it comes down to a legal principle. The Latin term is called contra preferendum, and it means you construe the language against the drafter of the document. The thought being that the insurance companies are drafting these documents, these insurance policies, and they're doing it in a way that puts vague and sort of ambiguous terms and provisions and conditions and clauses in there. And the law has said, well, you can do that, but when it comes down to it, we're not going to allow you to use vague and ambiguous terminology and then interpret that to your benefit and against your policyholder. So in our world, what Mallory and I do is we come up with ways to put forth a coverage claim that's based on a reasonable interpretation of your policy that supports coverage. So that even if the insurance company can come up with an alternative explanation, the general principles favor the policyholder. Okay, so that's pretty much the end of where we are on the legal and contractual and legislative front. But there's one other thing that I want to mention, and this is very, very important. So we work with clients of all shapes and sizes all across the country. And one of the things that we do in addition to talking about their specific insurance policy, we can talk about the messaging that has grown up around COVID-19. The reason that's important is because any public statements that you make, if you are posting signage on your place of business, if you are issuing press releases, if you're giving interviews, anything that would be construed as a public statement, it's a very natural thing for businesses to come out and say, it's okay, we're open, we've not been impacted, there's been no contamination here, we're safe, because that's what you want to do. You want to reassure your employees, you want to reassure your customers that there's really no reason to fear. Whoops, I thought somebody had a question, but we'll take those through. If folks can just text Mike the questions, that would be great. We're happy to answer all of them. Anyway, the point that I'm making here is that you want to be very careful in what you say, though it is a natural inclination to want to minimize the impact. Anything you say now will be used by your insurance carrier against you in the future. If you say, no impact, we're fine, and when things shake out, you determine that actually you did sustain quite a substantial loss, you're going to go back to the insurance carrier and make the claim for that loss. And the insurance company is going to start waving around those statements that you made and say, no, well, look, you don't have any loss. You told us right from the start that this had no impact on your business. Okay. In very practical terms, let me tell you how that works. It's one thing to post a sign or to make a statement that says, the safety of our customers is our number one priority. We're closing down, or we're closing down because the state says we can't stay open, or the city says we can't stay open. Okay, it's a very different way to message that, and the more consistent and better way to message it from the insurance perspective is to make a statement that says, as a result of COVID-19 and in keeping with the mandates of the federal government, state, city, whatever, that's why we're shutting down. Because what that does is that then preserves your ability to go back later on. And if the insurance company asserts that you have made statements that say there is no direct damage, you can come back and say, no, it says as a direct crime. That's not like shouting from the rooftops that, hey, my place of business is overwhelmed by COVID contamination. We certainly don't want to do that. The point I'm making is there is a way to message that will allow you to give the comfort you need to your employees, to your customers, while at the same time preserving the insurance claim for a later date. Okay. I'll close with one more point, and that is that when you're thinking about insurance claims, my kids would say, the insurance carriers are your frenemies. So what that means is you're going to make your claim. Your insurance adjusters are going to get back to you, and they're going to start peppering you with questions. And they're going to ask you a lot of questions because they are real to coverage. You need to be very vigilant in giving those responses, because once again, it's messy, but you want to be very careful that you are speaking, in the correct way, or using the right language, being very careful about the information that you're providing. You can't kind of go off the cuff, because that will come back and it will come back to bite you in the long run. So with that, let me stop. I will go back to Mike and see if we did have some questions come in. We're happy to answer those. And if folks want to text Mike on that, or if there's a way, what did you say, a little hand raise? We could.
Yeah, I saw a hand raised. I see a few Mallory's in there, so just want to make sure that we're being as responsive as possible. As Chris alludes, there's certainly some nuanced information in there, making sure you're doing the right things early. Mallory has certainly alluded to that as well. Some developments. Mallory, is there? I guess I'll ask you first. Is there a particular time frame with any of this stuff? I mean, it's obviously really hard to tell because these things are still in route. Is there any understanding of the horizon?
Not right now. The New Jersey bill that came out first was pulled because they were getting so much pressure from the insurance industry. But, then 4 more bills popped up from 4 other different states. So, logically, it would make sense that if this is relief that they want to give, the states want to give their businesses, logically, you would think that they would try and push this legislation through as quickly as possible, but there's no, definite time frame. Same with the Tria. They're kind of keeping that hush hush. There's no real time frame there. So as soon as I know, others will know.
Yeah, I'm sure a lot behind the scenes going on there. Thanks for staying on top of that.
Mike, on that, there may be a little bit of guidance. Tria that Mallory talked about was based on another federal enactment that came out following 9/11, and it was called Tria, right? And that's why they're trying to stick with the clever acronyms. That was the Terrorism Risk Insurance Act. That also, just like Tria proposed, and Tria is really following in the footsteps of Tria. It's a federal backstop basically to the insurance industry, whereas Mallory sees a sharing of the risk between the insurance industry and the federal government. Tria for quite some time, and I think it didn't come out for a year or two following 9/11. Now, I don't expect it to be that long if the feds are going to get in and do something. I expect it would be a much tighter timeline for a number of reasons, not least of which is they already have the blueprint with Tria, and if they follow on that, they can get it done a lot quicker. But as Mallory said, what's happened is states want to get out in front of this, and they propose legislation. Well, that's the easy part. Once you propose that legislation, that you have the insurance industry and their very, very powerful lobbying arms are coming in and saying, "Oh, what? Not so fast here, right? We have to work this out." So there is pressure. There is pressure to get this state legislation up and running. There's pressure to have the federal government step in and do something. But it really is very hard to tell any specific, time frames on that, just based on all of the, the various pressures from very powerful industry groups that are battling it out.
Sure. Thanks. And so if someone makes a claim, will their premiums go up next year? How does that process unfold? How are you seeing that?
That's actually a question we're getting quite a bit, particularly from small business clients. And the small businesses are concerned that, well, if I don't have a good shot to coverage, why bother to make a claim, because it's just next year, I'm going to have to pay more in premiums. Well, the truth of it is, when you have an event like this, everybody's premium is going up next year. Whether you make a claim or you don't make a claim, there is going to be a shared pain across the insurance industry. And already there is, it's very clear that premiums are going to be going up. So the fact that you could be leaving real tangible insurance proceeds on the table far outweighs that you're going to be facing increasing premiums in the future.
Great, thanks. I think that's great. I don't know if you want to leave it with a minute just of key takeaways. I mean, obviously, it seems that making a claim now is mission critical. Protecting your messaging is mission critical. Any other action items either of you would like people to walk away with today?
Well, I'll just say this, yeah, and you should have really said this at the top. Obviously, to the extent that we can be of assistance, we would be happy to help. There's certainly no obligation to hire us to help. The very, very strong recommendation, though, is you do not do this alone. You do, if it's not us, that you get another insurance coverage counsel to assist you. There are dangers in going it alone, as I said, in terms of the way a claim is tendered, in the way that you may be, or by any type of insurance industry professional, that you shouldn't tender a claim. Obviously, as we said, can't say strongly enough, or can't mention it enough, that you should put those claims through. And yeah, the prompt tender is key. The manner in which you message it is key. The way in which you deal with your insurance carrier is key, and the way you deal with the public. And keeping in mind that the only time that you can speak freely about concerns that you have with regard to your policy, and whether or not you may have coverage, and whether or not you may have exclusions to coverage, that's with your lawyers, and that's in a privileged setting. So if you're having those conversations with your insurance coverage lawyers, that's fine. You can be as free and open as you can in your emails and your Zoom calls and your telephone calls. But if you're dealing with brokers, and you're dealing with insurance consultants, or you're dealing with insurance industry, everything you say is a public statement. There is no confidentiality there. And so it's really, really important for people to keep that in mind when they're moving forward.
Great. Well, thank you both. Obviously, great insights from Mallory in terms of the developments coming around, and Chris, working with companies really around the clock in terms of providing these claims. We've recorded this session, so we're happy to send along contact information either through Mallory or Chris. And thank you very much. We appreciate it all.